He's board certified in pulmonary medicine in 1996, and he's board certified in critical care medicine in 1997. Decades of experience. He was also years and years doing lung transplants. Richmond agitation scale, you ever hear of that? Oh, yeah. Dr. Sessler, my friend Dr. Sessler. Yeah, from Richmond University. He came up with that. You heard from the guy that validated that. That is published in the Journal of American Medicine for validating the RAS score. That's in use here and all over the world. It's been translated in over 40 languages. This is the guy who 20 years ago, with his friend Dr. Sessler, validated the Richmond agitation scale is used throughout the world in medicine. There's just no justification beyond Thunderdome, is how I describe it. Like driving 250 miles an hour through a school zone while people are crossing the street and thinking you're not going to hurt somebody. He's been practicing more than 25 years and would never, ever use these doses. Why isn't there medical literature that supports it? There's no literature. Nobody does this. These were lethal doses. So while the defendant is good at the technical aspects, or what it takes to be a nighttime ICU doctor, I would argue to you, Dr. Ely shows you what it is to be a healer, a doctor actually, someone that is there to care for people and to treat them, even in their deaths. He's a technician over there, folks. He knows what he's doing. That doesn't make him a good doctor. Dr. Schweiger. Well, if you wanted somebody that had the same background as the defendant, because that sends you to a point that, well, Dr. Schweiger, Dr. Ely, internal medicine. Well, Dr. Schweiger has a background in anesthesiology that the defendant does, right? He has that. He's board certified in anesthesiology since 1994. So almost 3 decades ago, he was board certified in anesthesiology. But what else is he board certified in? Critical care, which is what we call a doctor who works in the ICU. And what else was he board certified in? Acute and chronic pain management. Boy, that's what I would argue to you this case is all about, right? I mean, this is the guy that is board certified and recognized as an expert in those fields. He's board certified in acute and chronic care management. He knows how to do it right. Had these patients declared themselves. Term of art we use in the ICU. That's the whole point. We're not doing this just as like as a way to spend money on somebody at the end of their life. You're sedating them, you're intubating them, you're paralyzing them, not because we want to run the bill up, we're giving them time. Time is what this is about. To let the body heal itself. Not all of these patients, he told you, within a reasonable degree of medical certainty based on his training and experience, had reached that terminal phase. And the judge will tell you, in the state of Ohio, the definition of terminal condition has a requirement that 2 physicians declare it. He told you lactate in the blood is not the same as lactate in the muscles, and his experience is not painful. And this is a guy that's board certified in pain management. Told you over and over again on each and every one of these 14 victims, there is no medical justification for the doses of fentanyl and benzodiazepine. I'd like you to consider, I wanted you to consider his qualifications, consider his prior experience. You heard from the testimony of Dr. Ziv. What did he really tell you? What did Dr. Ziv really tell you? I would argue to you he spoke in generalities. He didn't talk in any specifics about any of these 14 patients. Didn't talk in any specifics about the doses they were given. I would argue to you he didn't do that because there's no medical justification. He wants to talk about in general. You want to cover the pain. In general, you want to do this. And unlike Dr. Schweiger and Dr. Ely, who took the deep dive, the necessary deep dive, the reason this has taken 8, 9 weeks, however long we've been here, and wrote reports.
Objection. Verdict 15.
What?
Okay. What? I didn't hear what you said.
Burden shifting.
Okay. Ladies and gentlemen, it's the state's obligation to prove here. The defense doesn't have to prove anything. Okay, now, he can comment on the testimony of the doctor, but it in no way shifts the burden to the defense at all. Do you understand that? Continue on, Mr. Zion.
Unlike Dr. Schweiger and Dr. Ely, who took the deep dives on each and every one of these and made mistakes in their reports. I mean, one of the mistakes was he referred to the victim as a he rather than a she. But there were other significant mistakes about procedurally what occurred to some of these people. He said, oh, yeah, no, that's right. Yep, you were right. In the medical record, I had said this happened at this point, but you are clearly showing me right now, this is what happened. Yes, that was a mistake. Yes, that was an error. And they both did, because, I would argue to you, the massive amount of material they reviewed and delivered evidence on. What did Dr. Zivit tell you about any mistakes or contradictions? Nope, nope, nope. He didn't admit one thing was wrong with anything he said. What about the established medical science that's been tested, that all the other doctors in this case testified about the known synergistic effect, the potentiating effect when you give benzodiazepines and narcotic pain medication together? 1 + 1 doesn't equal 2, 1 + 1 = 2 = 4 or 5. And that wasn't just the experts. That was the doctors at Mount Carmel, the other doctors, his former colleagues. That was the pharmacists who told you that. That is a known thing. That is, there are studies about that. No, I don't remember. That's not. So when the science contradicted what he wanted to tell you, just that's not real. What about this organization you belong to and their recommendation? Oh, I resigned from that committee. I don't agree with that. What about when you testified previously? Oh, different context. What does that have to do with this? That has nothing to do with this. Different context. Wouldn't admit that there was anything contradictory or mistaken, except that apparently he accidentally put on 2 degrees he didn't have on his CV. That was one thing he did acknowledge he had made a mistake about. I would argue to you that what he is a crusader on is the government, the state, getting into the business of medicine. Doesn't like it when they do it in the death penalty. He doesn't like it when they do it here. And he's not some random doctor that was pulled from some hospital in Tennessee or Florida. Somebody sought out and said, what about this? He has a connection to the defendant. They share a mentor. So consider that in evaluating the credibility and the veracity of his testimony. Double effect. You heard a lot about double effect. First of all, it's not a law in Ohio. It is a bioethical and philosophical doctrine that doctors should be guided by, not just in palliative extubations, but in all they do. It is a recognized thing doctors have to consider, and that is the good must outweigh the bad. It's about proportionality. That's what this is about, proportionality. Does this good that we want to do, control pain, outweigh the bad, speed up death? So that is, while not a law in Ohio, it's something doctors need to take into consideration. And all of the doctors say, well, it's about proportionality and moderation. And that, what he's doing to these patients, all 14, is not proportional to any symptom they have, and is not moderate in any way or in any use. It is not a carte blanche for a doctor to do whatever he or she wants. The fact that there maybe have been more than one cause of death in each and every one of these victims is not a defense, as long as the drugs he administered were either the cause of death or the hastening of death. Remember that instruction when the judge gives you. There may be more than one, there may be one or more causes of an event. However, if these drugs were one of those causes, Even if they had these other diseases that also caused their death, it's not a defense that they were just really sick people and died anyways. And Dr. Ely and Dr. Schweiger were unequivocal. After their thorough and complete examination of these medical records, these doses either hastened or the out-and-out cause, especially in Melissa Penix's case, the out-and-out cause, he killed her with these drugs. Another thing, once again, we're back to that. This is about reason, this is about common sense. 12 people from the community of Franklin County. This happened in your town, in your county, folks. That's why you're here. What does your common sense tell you about that? Fentanyl is a powerful, dangerous narcotic pain medication with the known effect of suppressing respiratory function and can kill a person. Midazolam is a powerful, dangerous benzodiazepine with the known effect of suppressing respiratory function and can kill a person. These two drugs used together have a known demonstrated synergistic effect, which potentiates the effects of these drugs they have on their own. People die every day in our community overdosing on fentanyl. Not something we just call fentanyl, is really something else out there in the community. Fentanyl. The drugs he used, now not pharmaceutical grade, not of the purity he's giving them, but what everyone's out there dying and overdosing on.
Objection, Judge.
Okay. Sustained.
In your common experience, what is going out there?
Objection.
Judge, I'm allowed to talk about the common experiences of our community, and this is a
I
common
understand
experience.
what you're allowed to talk to. It's sustained. Move on.
Dr. Schweiger talks about the Utah study. This is one of the many studies that he testified about the known synergistic effects of these two drugs. The one that Dr. Zivit just said, I don't agree with that. These are 12 healthy men. And when they gave much lower doses than what he was giving to these very sick older people, 11 of the 12 had to be rescued. You're like, what are we here for? I mean, these people are so sick. Brian Hayes is gone. Drug addict. Timmons, gone. Drug addict. They're on their way out. Why are we here? Because it's a crime to kill a dying person, folks. So at the end of the day, though, you'll also be instructed on attempted murder. And this, you only get there if you feel the state has not proven beyond a reasonable doubt causation, in fact, on each and every one of these. And you're to consider each and every one of these separate and apart. That's why this has taken so long. These are 14 separate murders that in and of themselves would take a long time by themselves to try. But these are 14 altogether. So you look at count 1, and then you look at count 2, and then you look at count 3. And on any one of those, if you're not firmly convinced, your reason and common sense doesn't tell you 2,000 micrograms or 1,000 micrograms killed these people, actually caused their death, you may consider the lesser of attempted murder. And in attempted murder, before you can find the defendant guilty, and that's on each and every one of these, the lesser included is, was it his intention to at least try to cause or hasten their deaths? So you will be given the instruction of the lesser included offense of attempted murder in these cases. But only go there if you, as a group, no, state didn't prove cause on count 1, count 2, count 3, etc. Whatever count you're on. I say that way because it's not like an all or nothing thing. It is each individual count needs your separate deliberations. Don't go there as a compromise if you believe the evidence supports the greater charge. Attempted murder is the same thing as murder, just with the word attempt in there. The judge will tell you what attempt means. We talked a lot about this. We talked a lot about the purpose. What was someone's intent? Why was he doing this? Motive. The state need not prove motive. The presence or absence of motive is one of the circumstances bearing on defendant's purpose. And the judge will tell you, in the state of Ohio, you can have a good motive for doing something. You can have the best motive for doing something. But if it's illegal, if what you're doing is a crime, but I'm doing it for a very good reason. I'm doing it for the best of reasons. I'm doing it for mercy. I'm doing it because I think this is what good medicine is, quickly and painlessly causing the death of these dying people. I'm doing this because I want to be a good doctor and do good in the world. But if he is purposely causing their death and who's hastening their death by this, that good motive is not a defense in this case. We've talked a great deal about this in blood here for this very reason. Motive is the why. One of you said, when we were talking about, motive is the why. Why did you do it? Purpose is the intention. What did he intend to do when he did it? You can find that he might even have had a good reason as to why he purposely caused or hastened the victim's death. That's not a defense to the crime of murder in the state of Ohio. It's like what we talked about in voir dire with the vet, right? When your dog or cat is at the end of its life, that vet who has given great care to your animal throughout the course of its life, who's done everything, who's done miracles, to bring it along. But when it's over, and you've made the decision that it's time to, what we euphemistically call, put them down, put them to sleep, and you take them to the vet is not giving them that medicine because that veterinarian is a bad person with malice in their heart for that dog or cat that they've otherwise given great care to. They are doing that out of mercy because that is what you do to sick animals. But their intention is not just to cover the pain and let them die a natural death. Their intention, their purpose in giving the drugs they give those animals when they euthanize them is to kill them. And that's fine in veterinary science. That is not fine in the ICU at Mount Carmel or anywhere in the state of Ohio. Things not to consider. Of all the things, and I want you to consider all the evidence. And to reiterate what the judge just said, I want you to hold me to my burden. Because I've got to prove these things to you beyond a reasonable doubt. And this is too important not to hold me to that burden. So while I comment on what you consider Dr. Exhibit 4, remember, no matter what, hold me to my burden. Did I prove to you that he purposely caused the death of each and every one of these people? And of all the things I want you to consider, no matter who produces the evidence, either through direct testimony or through cross-examination, which was extensive, was excellent. The things I ask you not to consider are things like sympathy. Either sympathy for the victims' families who lost their loved ones and then were told months, years later, they did not die naturally. Or sympathy you may have for the defendant and for those that are here who love and care for him. Put that aside. Any bias you may have, either against the people that testified for the state, or any bias you may feel against anyone else involved in this, put that aside. The last thing I ask you not to consider, and the judge will instruct on this, is the topic of punishment. Punishment, if we get there, and I argue to you we should get there in this case, is reserved by law to the judge, Judge Holbrook in this case. And as I said in voir dire, I know it's on your mind after a guilty verdict, because if anyone chooses to talk to us afterwards, that's the first thing they ask, and that's fine afterwards. But in considering whether or not the state of Ohio is necessarily believing that he purposely caused the death of any of these folks, of all of these folks, I ask you to take that out of the equation and just consider the facts and circumstances and evidence. So what to consider? Everything that's been admitted to, the physical exhibits, the testimony and stipulations. That's the evidence in this case. Thank you.
Thank you. Mr. Baez, it's late in the thing. You want to stand up and say hello, and basically that's about it?
I'm more than happy to start when we all come back from lunch.
Okay, fair enough. Let's give you guys, we'll get started at 1 o'clock. Okay? Have a wonderful break. Remember the admonitions. It's particularly important you don't start discussing the case. You don't have the law yet, okay? With that, all rise. Have a great lunch, guys. Thank you for the coffee, by the way. Y'all can be seated. Okay, for the record, anything, Mr. Zion?
Well, we would like to talk about some of the slides the defense has provided to us this morning.
Do you guys want to do that here, or you want to do it in back?
You can do it on the side. I'm hoping this won't take long. But
Well, why don't we do this? Why don't we eat our lunch? You guys talk about it and see if you get a compromise. If you can't get a compromise, then we'll meet, let's say 22, 1.
sure.
That way my court reporter can get something to eat. Okay?
Okay.
Anything else?
No, Your Honor.
We'll get started with continuing the closings at 1. With that, I'm going to close the record.